Punks with Lunch, Lansing, and Kelsey Hector versus Derek DeLuke, Martin Fashan, and Julia Miller. Counsel, your appearances for the record.
Elizabeth Abdenor for plaintiffs, Judge.
Morning, Your Honor. Attorney Marcus Baldori on behalf of Julia Miller, who's sitting to my left.
Thank you. Good morning, counsel. All right. So this is the plaintiff's motion for preliminary injunction.
Thank you, Judge.
Mr. Baldori, did you have something you wanted to address first?
Oh, no, we can start with that motion. There's also 3 other motions.
Well,
yeah, that's okay. We can start with plaintiff's motion.
If there's a different order you all prefer, I don't have any problem with that.
I'm fine with this.
Thank you, sir.
Thank you, Judge.
You may proceed.
Judge, I'd like to call Julia Miller first, please. Thank you.
Are we having a hearing on this then? You want me to take some testimony?
I believe so, Judge, unless counsel's willing to discuss stipulating to an order, which I haven't heard about, so.
Well, I just thought it was a motion, not necessarily an evidentiary hearing. I'm willing to take some testimony. I do have some time this morning.
Sure, Judge. Well, so, I mean, I guess I wanted to take some testimony to address some statements that were in the defendant's response to the motion.
Why don't you just address them, and if I need to hear testimony, I will do that.
Okay, happy to do so. Thank you, Judge. So, Judge, what I'd like to address is that in the response that she filed with this court, defendant Miller stated in point 8 of her response, plaintiff's request is unnecessary because defendant has not made a public post about this matter in months and does not plan to post about it. The plaintiffs just became aware this morning of some additional posts on Reddit from the screen name PWL Julia from 9 and 8 days ago posting about this matter. So they really have no confidence that the defendant is going to be able to keep her mouth shut on this. And so that's really the additional information I wanted to present to the court.
All right. Mr. Baldori, is that your client's post?
I don't have that post, Your Honor, and if that's the case, then I don't know what.
Ma'am, please come up to the stand. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Please have a seat. Feel free to adjust the microphone so you can speak comfortably into it. When you are ready, please state and spell your name for the record.
Julia Miller, J-I-A-M-I-L-L-E-R.
Thank you. Ma'am, I need you to say yes or no, or words that can be found in a dictionary rather than or nodding. We'll remind you if you forget, many people do. If there's an objection, do not answer the question until I've made a ruling, and let counsel finish their questions before you jump in and answer. Do you understand the rules?
Yes.
Now, before counsel asks you questions, you just heard what the attorney for plaintiff said about the Reddit, correct?
Yes.
Is that your post? I'm sorry.
Your Honor, my only thought, I would like a copy of the post if that's
you
okay.
have
I'd
a
like to
copy?
be able to see that.
Judge, I just have a screenshot right now. They just found it this morning.
Great. Here's what you do. I would like you to send it to my law clerk. It's BRING, ring, like ring, at ingham.org.
Great.
He will print a copy for all of us.
Thank you, Judge.
Thank you, Your Honor.
All right, let's go off the record till that happens.
Okay, thank you, Judge.
I'm sorry, I thought you all would have had it, but we're good.
I just sent the photos. Thank you.
Perfect. I'll be right back.
same order, so if we need to reference on page 1, 2, and 3.
Council, do you need a moment to review these before we go back on the record?
1 minute, Your Honor.
Thank you. Let me know when you're ready.
Ready, Your Honor.
All right, let's go back on the record. Ma'am, I'm handing you a copy of this. Do we have an extra copy?
No, but I can make one real quick.
I'm happy to have the court use mine.
Thank you. Um, We're going to mark that as court, or well, I'm going to mark it as, I guess, plaintiff's exhibit 1. Any objection to that?
Objection.
All right, and it references a PWL Julia. Is that you, ma'am?
That is my account that I use, yes.
I did, my account I use.
She said that is my account that I use,
Yes,
yes.
I said that is an account I use, I don't normally go on, like, I haven't remembered.
Well, ma'am, have you had a moment to review
Yes.
those? Did you write those?
These, yes, this was, yes.
Okay, so despite receiving a cease and desist letter and not or being advised not to talk about this, you've continued to do it, but just on a different platform, is that correct? Yes or no?
Yes, I was responding to a screenshot somebody had posted regarding a post that had been made months and months ago that had just recently been somebody else, I don't know who, reshared onto Reddit. And this person that I was responding to made some claims and accusations that were completely false.
Okay,
Um,
okay, that's all. Counsel, you may proceed with questioning.
Thank you, Judge.
Unless there's any objection, I'm going to admit this.
Yeah, there's no objection, Your Honor.
Thank you.
You know, I actually could make one comment. You know, I may be open to stipulating to an order that no further online communications can be posted. That's, this is news to me, frankly.
I see the surprise, and
And so-
surprise is part of what we do in the law,
And
so if
that's-
you
yeah.
would stipulate not just to, what I would like to see here. I mean, this is ridiculous. This is a very good organization. I don't know what's gone on. We have a court of law to have a jury trial or a bench trial to figure out damages or whatever it is you all have complained about and need to be heard on. But this doesn't help anybody's case. It doesn't help serve the public. And what we're doing, and by your own admission, ma'am, there's a lot of replies that the community is interested in this for many reasons. So it's stirring the pot for no reason and could hurt either side's right to a fair trial and fair jurors. And so I don't understand why any of this needs to be responded to. So the stipulation that I would like to see, and you all can draft it and argue with me here, is that all this crap gets taken down and there is no more. And we fight about this in a court of law with evidence, not speculation, supposition, and tainting of a jury pool that doesn't necessarily need to be tainted prior to evidence. Can we do that?
Yes, Your Honor, my client and I'll direct my client to stipulate to that, and we will stipulate to that, Your Honor.
Now, my understanding, and yes, is there freedom of speech? Yes. Okay, and I know that's been asserted here too. And that's part of the Constitution. The problem is that you are ruining your case. All of this is going to be found out one way or another. It will be used to impeach you, discredit you, or the other side, depending what's going on. And it's harmful to the case. So I would ask you to refrain from using your personal account, Reddit, Instagram, Facebook, TikTok, any of the platforms out there from discussing this. It's harmful. So maybe we could craft an order saying that during the pendency of this, there is no discussion publicly on either side. It should be mutual.
Judge, I think that's fine. I don't believe my clients have done so, so I think that should be fine. Are you good with that?
It is essentially a gag order.
Yeah, no posting about this case is just, I mean, let's hear from Ms. Miller. Is that, we agree to that?
As long as it's mutual, I know for a fact it has not been mutual, but as long as.
Well, I'll decide what the facts are. If you know, if you want to dispute this all day long, we can do it, ma'am. You just said you don't know who did that and it was from a long time ago. And what's happened is all of your posts have stirred the pot. And so we're going to end up with a lot of anonymous crap that is never going to come into trial. Could be deadly to somebody. This is just, it's how cases get ruined and people get hurt. So let's not do it, no matter where it comes from. And if you've got some allegations, it takes evidence. You have a very competent attorney, so does the plaintiff, and they'll present it to me and I will make a decision. Does that make sense to you?
Yes.
Great. Any other questions at this point?
Not for plaintiff, thank you, Judge.
I have no questions, Your Honor.
Thank you.
Yeah, thank you.
Please hand that to me. So you'll work out the details and certainly I am here for that. Now, what are the other issues
Thank you,
here?
Judge. Judge, I believe the rest of the motions are defendants.
Yeah.
Mr. Valdori, you may proceed.
Thank you, Your Honor. I'll start with the motion to strike.
Would you mind coming just for the ease of the corporate podium?
Sure.
I'll give you a moment to gather your papers.
Absolutely.
Thank you.
Ready to proceed.
You may proceed.
Okay, yeah, so this is a motion to strike and request for evidentiary hearing on this matter relating to the proof of service. What I want to point out first is that I'm not raising a jurisdictional issue. We're in this court. We've filed an answer. We understand that. We're here. That's not my purpose in bringing this to the court's attention. But I thought it was important to bring this to the court's attention based on what this underlying complaint is all about, which is plaintiffs asserting that my clients breached fiduciary obligations and broke a bunch of rules in relation to this company. Meanwhile, you can see my client's affidavit attached as one of the exhibits. They did not personally serve my client. They did not hand the documents to my client. They left it on her porch and she found it a few days later.
Was there an alternative service signed by the court?
Judge, I do have Ms. Stoner here. She was the attorney handling the matter at the time. I only know what is in the court's record, which is the proof of service that was filed by Ms. Stoner.
Okay, but it has to be personal or through the mail unless the court allows tacking or otherwise. So, but counsel, I understand you're asking them to abide by the rules, but you've appeared before the court. You're not denying the jurisdiction of this court or that there's a case. What would you like me to do on this?
Well, it's a clear violation of the signature rule.
Okay.
And sanctions. To some extent, I mean, this is an attorney. This isn't just some random process server. This was the company's attorney. And they're alleging that during the course of all of their time at this company, my client did all these bad acts. Meanwhile, they're presenting a document to the court. And I came in here understanding the court may not, want to dig into this. I understand that, Your Honor. But when I'm dealing with, my client had these documents from June or July, and they just sat on it right until the moment that the summons was gonna expire. And then they filed this, I think probably knowing that it was dubious, and it's signed saying, I personally served Juliet. That didn't happen.
All right, let's call the witness. We have one. I've got time this morning. I had another issue canceled. So, ma'am? Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
You may have a seat. Hold the chair right up to the microphone. Please state and spell your name for the record.
Rebecca Stoner, REBCCA STONER.
And ma'am, you are an attorney.
I am.
Did you personally serve defendant?
I believe that I did.
You don't believe. What I always say to people is take your beliefs to church, got evidence. I want what specifically happened. Did you put it in her hand or not? You know, as an attorney,
No,
what
I did
person.
not put it in her.
Then why did you sign the affidavit? That is a breach of your ethics.
At the time, I believed that I had personally served her.
What is your understanding of personal service?
Well, she had been an unwilling recipient. I had sent her a certified mail to her address and she had flat rejected it. And so I thought that if I brought it to her household and saw her take it off her porch, that would be adequate. And I was wrong. Liz corrected me on that. I don't.
That is wrong. What you do, and I sign these pretty regularly every week. I have a stack of people who do the same thing. No one wants to accept paperwork from a lawyer. So there is a motion that you file that they've been uncooperative. So you use personal service with a process server. You use tacking, publication, and there's a very specific court rule. And as counsel, that's a very basic rule that you should know. I am unclear how you thought what you did was acceptable, ma'am.
I don't generally practice law. I am a barred attorney, but I work in contracts and have for the past 15 years. The only reason I got pulled in on this matter was I'm a volunteer with Punks, and I got a very tearful series of phone calls from the board when this matter came to the fore, and so I volunteered to assist.
Your Honor, empathy does not negate your responsibilities to abide by the law, the statutes, the court rules that we all operate under. And the answer is no. If you don't feel you're able to handle a case, you say no and you refer it on if you can. Were you going to file an objection?
Judge, what I was going to object to was Ms. Stoner testifying about anything that she discussed with her clients, as that is attorney-client privilege.
Okay, well, I'm only interested in this, but you should not, again, reveal anything you discussed with your client. Did you have any questions?
I have no further questions. We've
Did you have
established.
any additional questions?
No, Judge, thank you.
I'm going to step down, ma'am.
Thank you.
Your Honor, I appreciate Ms. Stoner's honesty at that moment. I mean, that's nice that she was honest about that. I mean, obviously, it's a significant issue, frankly. I mean, we're here in court. That it's not a jurisdictional issue. I'm not worried
Okay,
about that.
so are you waiving the defect in service so we can proceed, or do you want this case do you want them to personally serve you? We can get you served in court, or what would you like?
No, that issue is waived, Your Honor. We're here. We filed an appearance. That's not
Great.
my purpose with this, Your Honor.
Okay.
My purpose was potentially getting it stricken and potentially sanctions. Whatever the court's inclined to do, that's fine. I think that it is a sanctionable issue. It's a violation of signature rules. She filed a proof of service saying she served something that she didn't. And I appreciate her honesty, but that's a significant issue. I deal with these service issues constantly, all day, with different cases I have. And this is a very sensitive topic. You can't just file fraudulent documents with the court. That's what it was.
So, sir, as to this particular motion, how long did it take you to draft?
Drafting and filing about maybe an hour to 2 hours.
And So how much do you charge an hour for this? How much did you charge your client?
$325 an hour.
Great, ma'am, you are sanctioned $325. I'm just gonna leave it at that.
Okay.
Because the rest, the state bar is gonna have to take care of. Once I hear a violation, it has to go to the state bar. There is, and they'll take care of the rest. And you're going to have 30 days to pay that to, council.
Thank you, Your Honor. I'll move to the next motion. I appreciate it.
Next motion,
Okay. Defendant Julia Miller's second motion that was filed as her motion for advancement of attorney's fees. So this stems from the bylaws of Punks with Lunch Lansing, which is quoted in the motion in section 5, where it states that the corporation must determine that indemnification of the person is proper in the circumstances.
The person's what?
I'm sorry. The corporation must determine that indemnification of the person is proper in the circumstances because the person has met the applicable standard of conduct set forth in sections 5.01 or 5.02. And prior to that, in section 5.01, it states that directors, former members are indemnified and held harmless against expenses, including attorney's fees. And I made that request for Punks with Lunch to make that determination. They've refused, haven't responded whatsoever because they don't want to pay our attorney's fees because their complaint.
Objection, counsel is testifying about what plaintiffs want without having,
that's it from his, I overruled. I'm gonna
Thank you,
hear
Judge.
this
Okay.
and, I want his understanding, then you can tell me yours. I have an idea of what I'm gonna do, but
Okay.
let me hear him out.
Right, well, Your Honor, so just to get at this, that we're just requesting that it's placed in escrow. We're not asking that it goes to my client. I think we just want to place in escrow. She's accruing significant attorney's fees, and clearly these bylaws cover this. She denies all the allegations adamantly, and one thing that is somewhat of a red flag for me here is that the primary defendant, Derek Duluth, in this matter, has not, as far as I know, they haven't even tried to serve him. And he's the one that allegedly took the money out of the account, so on and so forth. I'm not testifying on the record, I'm just saying this is the allegations in the complaint. And so we're racking up time, we're here in court.
Well,
and
have
he
you
hasn't
tried
even-
to bring him in?
I'm sorry?
Have you tried to bring him in?
He's a defendant that the plaintiffs have, and I've considered filing a motion to compel them to serve him. I wanted to potentially work it out amicably, but regardless, that's for them to speak to. That I agree, Your Honor, he needs to be here for this case. I 100% agree, and we're going to push that process forward. In the meantime, as it relates to this motion, I think it's appropriate for them to put some funds in an escrow account pending the resolution of this case, because clearly these bylaws for the corporation that my client founded, by the way, state that there's an indemnification for members. And if these allegations and counts do not state, which I do not believe that they will, she's going to qualify under these bylaws. And for that reason, I don't want her to get stiffed. I mean, there should be at least some kind of again, an escrow account. I don't know to what extent I indicated the amounts I'm requesting in there, but that's what I have to say on that motion. Your Honor.
So tell me how Derek Duluth and Martin Michon fit in here, from your understanding.
Okay, so those are Martin Michon, I don't have much knowledge about. Derek Duluth is the individual in their complaint where he took money out of the nonprofit's account and essentially disappeared, both to the company and my client. They grouped my client's conduct along with Derek Duluth. Our general argument in this matter is that that's simply not the case. My client was not aware of his conduct. His status as an employee with Punks with Lunch was not something just exclusively part of Julia Miller. It's not like she brought him in and nobody else knew. Everybody knew he was part of the company and the authorizations that he had related to this company. What the plaintiffs aren't seeing is that my client wasn't responsible for any of his conduct, truly, and she's going to testify to that. So that's where this case is going. Obviously, we need, like, for example, if Derek Duluth is defaulted on this and every single allegation in their complaint is admitted as true, if he's defaulted, I don't know how they could prove their case against Julia Miller when he's admitted to all the, I mean, there may be avenues for that, but I'm just giving him an example. If everything that he, in that, their complaint is admitted as true, if he gets defaulted, that's gonna knock out many of their counts to their complaint. And it's going to make it very difficult for anything to stick against Julia Miller if he's defaulted, because it's essentially like him admitting to everything, because you're frankly, from my client's standpoint, he's the one who was really responsible for these issues. So I'm just giving you a taste for where this is about to go. And again, I don't believe they can prove any of these counts, certainly not, I mean, really any of them. And so for that reason, again, back to the motion, it's just, there's a very comprehensive indemnification clause. It's actually more comprehensive than I would usually expect to see. And and again, I'm not asking for them to front the fees right now to her. I'm asking just for them to be set in an escrow account.
So you're basically claiming that this is a vexatious pleading and she is due the monies based on that. Have a seat, let me hear the response.
Thank you, Judge. So first, if we need to take testimony on this, my clients will be able to testify to the fact that Julia Miller was in a romantic relationship with Derek DeLuth. So the idea that she had no idea what he was doing or what was going on is simply not going to align with the facts. Ms. Miller was the person who provided Mr. DeLuth, who, my understanding, and this may be incorrect, is that he was just a volunteer, but he was given a debit card for the organization, which simply doesn't make logical sense from a fiscal responsibility perspective. He was an employee. Okay.
Let me just ask you something. Was Mr. DeLuth and Mr. Michon, have they been served?
So I just received service forms back yesterday, Judge.
Proper service?
Wait, you just received what service?
The service return, yeah, so let me explain what we received back. We sent them out restricted delivery, what we received back for, Mr. DeLuth was, signed by someone named Harley Curtis, who it's my understanding is his current girlfriend. She checked the box saying she's his agent, but from my view, I don't think that's good service, so I think
That's
we're gonna have
not
to keep
good.
trying.
I'm not going to accept
Right.
that. You can do an
Yeah.
alt service if that's.
Okay, that's what I'll do, Judge. And then with respect to Mr. Michon, we received the green card back with absolutely nothing on it at all. So I don't know, not even we attempted to serve and couldn't.
So you need a process server.
Yep.
And or alternate service, because right now, the only one you have in the case is Ms. Miller, which is only a fraction apparently of this story, so that we can do proper discovery without delay, get this to trial or resolution, whatever, so it's not out there. In terms of the money, I'm gonna hold that in abeyance. I don't know if this is a vexatious pleading or not. If it is, we're gonna talk about that. If it's not, if there's a wrongdoing, I really don't care what it says in the wrongdoing would likely, I haven't read the whole contract here or agreement, but a wrongdoing would likely get rid of the indemnification, because that would be like a frolic and detour on their own instead of acting under their responsibilities. So we'll talk about that as the proofs come in. So it's held in abeyance. And I need you to get those other two served quickly. This case and these issues with the work that's being done and with all the things that are going on, let's get to it.
Thank you, Judge.
So you'll prepare an order as to that, this is preserved.
Yes, Your Honor.
What's the next issue?
Last one here. This one's simple. It's just a motion for us to file a, the last one's just a motion for us to file a counterclaim in relation to Julia Miller.
A counterclaim, have you filed an answer?
Yes. We
So
filed.
you want to amend to do an answer and counter complaint?
Yes, so we've already, Julia Miller has filed her answer to plaintiff's amended complaint. They filed an unamended complaint, and we filed our answer. We've also filed initial disclosures. Separate from that, we have a counterclaim that we'd like to be able to file within 7 days. I attached it as an exhibit to the motion. There might be minor changes, but the 3 counts will remain the same.
I take it you're objecting?
Judge, the only one we're objecting to is count 2, which says it's a claim for advancement, which I could not find recognized under Michigan law.
I'm sure that he'll clarify that as he's allowed to draft, so I'm going to allow, there's no reason, we're so early in, and there's good cause here, this case is a mess, so, but please, Michigan is a notice state, so please be very specific in providing notice as to each of the counts, and you're allowed to do that within, I'm gonna give you 21 days.
Okay,
so-
21 days.
All right. Anything else?
No, thank you, Judge.
All
I
right.
have nothing further, Your Honor. Thank you.
All
very
right,
much.
that resolves everything for today
For plaintiffs, yes.
and for defense. So that,
Yes.
I will look forward to, once everybody's served, we will have the scheduling order. I'll bring you all in and we'll figure out where we're going with all this.
Just a question on that, Your Honor. So is it my understanding that scheduling order or a conference date will not be set until the other 2 defendants are served? Is that?
That's the way I would like to operate, because even if we did, we could meet today, Ray, you're both here, but it'll all get changed. So why? Let's
I
figure
agree.
out the issues and settle them. I prefer a straight path rather than one that veins out and it becomes muddled. So let's do that.
Thank you, Judge.
If I can be of assistance, schedule in front of me or just get me on the phone, a conference call or Zoom hearing, and let's just get this case moving.
Thank you.
Thank you, Judge.
Thank you, that's all for the record. You'll both draft your respective orders, correct? And you'll work together on that?
Yes.
Yes, thank you,
We'll
Judge.
Thank
All
you.
right. Very good. Mr. Valdori, tell your dad hello.
I will.
And your mom.
Yes.
Thank you.
Almost dragged him here today.
Yeah, you should have.
Yeah, I know.
Maybe that's why.
Yeah, I didn't even have a copy of the motion, so
And no one's on Zoom.
no one's on Zoom.
This is, you know what, our former law clerk, Stephen Fauquier, what the heck?
Something.
MJ,
This, no, Stephen Fauquier, do you remember him?
I don't think I was here for Stephen.
He's also a former TPI student, he should know better than to call. All right, what was this? Here's the scheduling order, I don't even see what this was scheduled for.
It was scheduled for motion to compel, but I
It's
didn't,
not in here.
I didn't see a motion. There was no.
All right. This is docket 253768NF. Melvin Bleisner versus Liberty Mutual Personal Insurance Company. On the court's docket, this was scheduled for 10:30. It is now 10:50 and no one has appeared and there is no filing that the court can find by either counsel. Therefore, I'm going to deem this motion abandoned. The next matter is for a scheduling conference, January 9th, 2026. And at that time, if no one appears, I may consider dismissing the case. That's all for the record.
She could come in now, I guess.
Is Judge in here? Oh,
We're not going back on to one after this.
Correct. Maybe we'll see if she's praying next to that.
I was gonna say that.
You don't have to go. Well, like, I don't know if no. Yeah, luckily I don't have to do civil, so I got my whole bunch of, like, even, I don't know. Brian, I was like, dude, it's hard on me too, like, especially you, you're doing 20%. It's like,
I
it's
can't even
stressful.
think with how fast the time is.
And then it's not even that. 90 seconds between here. Like,
Nothing, and I said, wait a minute, next.
like, can you wait? You know, I don't like to wait a minute, even for real, when I'm trying to do my court notes, I don't get it done, like, she might add something right then, I still have to
Or let's
scan
go
it.
back
I had them two printed out, and I have them all written down, I have my commitments, my jail, and it's, oh, I have to remember. Alright, the other one, but when she didn't take the guy's plea, I'm glad she did. I already had all that filled out, like, oh my god, I have to redo all this. And then
Delete.
delete, and I will write it down of the stuff I had to catch up on. And I'm a decent typer, I'm not like the quickest type in the world, but
I know, and I have those nasty things because of me.
Because, well, what's happened to you is I'm like, no, not happening, Judge. I cannot. There's too many disruptions.
I will say I've gotten used to it.
And Brian complains, but I'm like,
He does, he does. I don't, because I don't know their jobs, so I don't wanna, I know your job, and I know that's hard to tell. But like, you know, judge or, because a lot of volunteers, they complain about their.
yeah.
I don't know their job. I have no idea what you do, so how am I gonna sit there and criticize you?
I just see her page, okay, I need to get out of here.
Yeah.
One, I don't like when that comment happens, especially downstairs. There's one that's kind of reflection. Because I'm the clerk. One.
Yeah.
And but that is true, like. But that down now.
The misfit court.
But I feel like we always have
I
the
see that.
highest cases, the most publicity cases.
I think so too.
I try to do a great job.
When I see it, it's like.
One time I was looking over, I was gonna ask him something. He's like, okay. And then I love judge. I guess I don't know what you do. Please don't judge.
Oh,
Really kind of.
yeah. And I'm waiting for the doctor to call. And she goes,
Yeah.
and they have to send my clip.
Sometimes though, sometimes she'll do stuff that she shouldn't do. And I just have to tell her, so keep on, so then I had to tell her. I don't look a lot of I don't have to go to law school and she did.
Yeah.
Like she'll, I missed a meeting, it's been like a year. You can't do that.
It's misdemeanor.
I agree, it's whatever I tell her. Or she'll
Because
get off
then
the
it
record,
brings us back.
it's like, we don't even have their sentence. She's like, and they'll be walking out the door, it's like, Judge, what was their sentence?
Yeah.
Oh, time served. What's the credit? It's like, I don't know, you just shoot them out of here. And then I'll send a commitment, and if it gets sent back, that was better.
Right.
I'll send
because
an MDOC commitment. It's just, it's, I do enjoy being up here. I enjoy being up here. Some people that complain, always gossip about something, and they're complaining a lot. I need to do, like, honestly,
There's some people.
it does, like, I'm gonna start bringing even on my docking stuff here, because this scanner, they said they only got this for us, like, just for the. Obviously not on the record.
I'll be up just a second.
More specific.
Black man though?
It sounds insane.
Black, I think it's black.
No.
Like, oh. Marquis Anderson? The one we just had?
No, this was from like at least a couple months ago. At least. So I did have like Echo came be more specific. She's like the one that was we talk something about Lee and do a TED talk.
I do remember him.
I go, I know I did the transcript, but I don't know his name.
No, I could pull it up. Steve was.
She wanted to say Clarence, but it wasn't Clarence.
It might have been he was.
See, now I got it in your head.
Yeah, he was also here the same day for the home camp.
Yeah, and I can't find, I know I did the transcript. That's how she works.
I appreciate you being so.
And I look at Brian and I look at her, I'm like, "Be more specific," and Brian starts laughing. She is, I'm thinking, 16.
She's actually doing well.
Yeah, she's, I'm trying to.
She's pretty sharp in that sense.
Yeah.
Like,
She's, I know, it only takes, like.
just you took out 25% of the other.
It's a big.
All right.
Thank you, you may be seated.
Admission letter, the order.
You've got the order?
I have the admission letter. I don't have the order.
Let me see what I've got.
I thought Brian.
I think I've got it.
Welcome to the party.
One, two.
I was gonna say welcome to the party.
So are we doing the other swearing in tomorrow?
Yes.
All right. This is in the matter of the petition of Rachel Zuli. Who brings this petition?
Good morning, Your Honor. I am Christina Bilowis, P number 78104. I'm sorry. Oh, I just read. Thank you, Your Honor.
Thank you. On what basis are you bringing this?
Good morning, Your Honor. It's my pleasure to bring this petition on behalf of Rachel Zugli in support of her admission to the State Bar of Michigan, Your Honor.
And who have you brought with you?
My boyfriend, Nick, made us.
All right, sir, are you a picture taker?
I can be.
All right, well, in my courtroom, anyone who appears is allowed to sit in the jury box because as beautiful as the back of her head is, I'm
Wow.
sure you would like to see the front. And also you may move freely around the courtroom to take pictures to memorialize this if you wish.
Yeah, 2693.
So you don't have to be shy saying, you can come here, you can walk in back of me as long as you're quiet, we're good. Thank you. And I'm sorry, on what basis are you bringing this?
Your Honor, in support of her admission and completing the requirements before the State Bar, and I have prepared with Your Honor's permission a brief elocution speaking to Ms. Zubli's attributes.
You may.
Thank you so much. First and foremost, Your Honor, I'd like to thank this court, especially Your Honor, for putting us in on a tight timeline before the holiday season. It is truly a boon to Ms. Zubli and myself, and we graciously thank you so very much. In support of the admission for Ms. Zubli, I'd like to share a little bit about personally and professionally what she's accomplished. Personally, I got to know Rachel better as a graduate than I knew in law school. I had seen her involvement with student orgs. I had seen her interactions with the online campus interviews and back and forth communications. She always was super professional, very intellectually curious, very responsive. But when I got to know Ms. Zubli post commencement, was really seeing the depth in her intellectual acumen. She was looking for work. She was figuring out all the things she had to do for the bar exam, studying for the bar exam, making tough decisions whether or not to be here in Michigan or also her return home, which is in New York. She was managing all these things well beyond her years. And I got a chance to speak with her about what she was looking for in work, as well as what she was looking for in a career. And what stood out the most, Your Honor, is her commitment to service and meaningful work as an advocate. And as a new attorney, we've seen this across the board, but this was someone who really went above and beyond. Having academic excellence at Columbia University, where she graduated with a 3.79. She was on the Dean's List. She served in the Alpha Lambda Delta First Year Honor Society. She went on to distinguish herself academically at MSU with a 3.48. She won jurisprudence awards in research writing and advocacy and advanced legal research. So right away, looking at her professional acumen, I could see that being translated in written and oral recitation. She had a full tuition scholarship, and she also spent a great deal of time with the disability rights in Michigan as a volunteer. Prior and during her time in law school, she had substantive and substantial legal work. She worked as a legal assistant at Brookstone Realty in New York.
Brooks what?
I'm so sorry, Brookstone Realty. Neiman Turkish PC, and then Herzl Law, where she had started her career here in law school and during and after. She now is set for a career in early January with the Manor Law Group, and she'll be working out of the Grand Blanc office. And finally, in further support, she has displayed the utmost amount of commitment as well as intelligence and commitment to the profession. She wants to make a difference. She knows her skill sets and she's looking to hone it. She looks to advance also with volunteering. And so for all these reasons and more, Your Honor, it is my humble request to admit Ms. Rachel Zubli to the State Bar of Michigan. Thank you.
Very well articulated, counsel, and the fact that she has chosen Michigan over New York is impressive, along with her many credentials. So, counsel, your motion is granted.
Thank you so much, Your Honor.
Please raise your right hand and repeat after me. I do solemnly swear
I do solemnly swear
I will support the Constitution of the United States
I will support the Constitution of the United States
and the Constitution of the State of Michigan.
and the Constitution of the State of Michigan.
I will maintain
I will maintain
the respect
the respect
due to courts of justice
due to courts of justice
and judicial officers.
and judicial officers.
I will not counsel or maintain
I will not counsel or maintain
any suit or proceeding
any suit or proceeding
which shall appear to me
which shall appear to me
to be unjust,
to be unjust,
nor any defense
nor any defense
except such as I believe
except such as I believe
to be honestly debatable
to be honestly debatable
under the law of the land.
under the law of the land.
I will employ
I will employ
for the purpose of maintaining
for the purpose of maintaining
the causes confided to me
the causes confided to me
such means only
such means only
as are consistent with truth and honor,
as are consistent with truth and honor,
and will never seek to mislead
and will never seek to mislead
the judge or jury
the judge or jury
by any artifice
by any artifice
or false statement of fact or law.
or false statement of fact or law.
I will maintain
I will maintain
the confidence
the confidence
and preserve inviolate
and to preserve inviolate
the secrets of my client,
the secrets of my client,
and will accept no compensation
and will accept no compensation
in connection with my client's business
in connection with my client's business,
except with my client's knowledge and approval.
except with my client's knowledge and approval.
I will abstain
I will abstain
from all offensive personality
from all offensive personality
and advance no fact prejudicial
and advance no fact prejudicial
to the honor or reputation of a party or witness,
to the honor or reputation of a party or witness,
unless required
unless required
by the justice of the cause
by the justice of the cause
with which I am charged.
with which I am charged.
I will never reject
I will never reject
from any consideration
from any consideration
personal to myself
personal to myself
the cause of the defenseless
the cause of the defenseless
or oppressed,
or oppressed,
or delay any cause
or delayed cause
for lucre or malice.
for lucre or malice.
I will,
I will,
in all other respects,
in all other respects,
conduct myself personally and professionally
conduct myself personally and professionally
in conformity with
in conformity with
the high standards of conduct
the high standards of conduct
imposed upon members of the bar
imposed upon members of the bar
as conditions
as conditions
for the privilege
for the privilege
to practice law in the state of Michigan.
to practice law in the state of Michigan.
You may put your hand down. The oath that you've taken now begins a new life. You've already been living that life, and I was informed about many of the great things you've done, but those must now continue at a higher level. Civility is forgotten amongst many attorneys. I know that you will never forget that. No matter how upset, we must preserve the respect due to courts, due to attorneys, due to your clients, due to jurors. The whole system falls apart if we don't respect it and act with civility at all times, even though you may be angry. You keep your power and you do not let it show. Many have forgotten that. I often threaten counsel with contempt if they don't behave well. And so this oath reminds us that it has some old language, but that old language is tried and true, like many of the ancient cases we were all taught with in law school. And there's a movement to change it and bring the language to current language, but I disagree with that. Because when something is tried and true, it sends a message. It sends a message that is valid and that it works, and that we must always remember it and abide by it. So to memorialize your new life as an attorney, both personally and professionally, please approach and affix your signature to the oath so that you always remember the oath that you've taken publicly. Now, with that signature, you should have been a doctor, maybe. But, it's truly an honor to have you here in my courtroom. This is not an inconvenience, it's an honor. I am always happy and willing to fit in, especially Michigan State students, because not only do I teach there, but I had hoped to attend Michigan State College of Law, but they didn't have one when I went. They were building one and then stopped building the library. So I didn't have the honor of going to both undergrad and graduate school at Michigan State. But I do love the law school, and I think, and I've seen, and I'm part of, a small part of making sure that those people who graduate and take the oath are exemplary in every way. And it speaks volumes as to what your sponsor has said about you, and about the education, and about your commitment, not just to law, but to being there for those who can least afford it. The practice of law is not about money. And there are those attorneys, and you will meet them, those attorneys who want the bottom line dollar, not the bottom line result. And the bottom line result for your client is not whether you win or lose. Everyone wants to win, but no attorney wins 100% of the time. But every time you are that advocate, that voice for your client in what usually is one of the worst things that happens to them, or one of the most important moments in their life, being that voice, that is what's important, so that everybody who leaves your office or the courtroom understands that they were heard, they were believed, their advocate put their best foot forward, and then regardless of the outcome, they win and everyone wins along with them. Having presented to the court the certificate of the State Board of Law Examiners showing that petitioner has been duly examined, fully qualified, and possessed of sufficient learning in the law, moral character, and ability to enable petitioner to properly practice in the courts of this state. Therefore, on motion of Christina A. Billows, the court being satisfied thereon, it is ordered that petitioner be and is hereby admitted to practice as an attorney and counselor at law in the courts of this state. We have a certificate of admission that also recognizes that Rachel Zuli, having duly completed all prerequisite requirements, is hereby admitted to the practice of law in the state of Michigan with all rights and responsibilities vested therewith. The court has signed it, and I would ask your sponsoring attorney to approach and sign it as well. Now, we print both your oath and this certificate on nice paper. You can file it away. You can also frame it. The reason I would suggest, it's not in order, that you frame it is because you should place this somewhere where you don't just see it, but your clients see it. And sometimes more important, opposing counsel who shows up in your office for a meeting or a deposition or whatever it is, sees it. So that everybody is reminded of the oath and reminded that they should put their best foot forward. Because that is what we've all sworn to uphold, the Constitution and the rights of everyone with respect, zealousness, dignity, and civility. So that is why I print this. Again, you do what you want with it, but I think the reminder always needs to be there. Because while you may not have forgotten it, and I hope and I don't think you'll ever forget it, you are going to come in contact with many people who have forgotten the oath and are at their worst moment. And it's those moments you have to pause, take a breath, smile, and be at your best. With that being said, I congratulate our newest lawyer.
Thank you, Your Honor.
And it's not done, because in my courtroom, when I have the privilege and honor of swearing you in, I also have the privilege and honor of hearing you speak your first words at my podium in my courtroom. Counsel, what would you like me to know?
I would like to thank my family for their unwavering love and support, without which this achievement would not have been possible.
I appreciate that, because there isn't a lawyer I know of who hasn't relied on their family to forgive them for eating a fast dinner and then going to study, not showing up at holidays, doing their laundry, putting an extra $20 in their pocket, whatever. The amount of support we need from our families is endless. So it tells me you are going to be a very conscientious and thoughtful and thankful attorney. So congratulations, please approach.
Thank you.
All right. Now we have, do you have a certificate you need?
I need the order.
Okay, we have the order. If you could present him with the order, that's part of that. We will get that taken care of. All right, so did you wish to say anything on the
If you
record?
just need one, I'll make the rest of it.
If you do, you have to come over there. See, I know you're not a criminal, but you look fine.
Thank you so much.
Swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury.
Absolutely.
Please state and spell your name for the record.
Nick Mavis, Nickmabis.
What would you like me to know?
I mean, we've all heard what most people are gonna say, but I mean, personally, I couldn't be more proud of her. I live next to this person. I saw what, as you said, family support, money, emotional needs. I mean, the wave that all of you have gone through is, I mean, it's next level. People don't really understand until they know someone that actually goes through it. I mean, we just assume, a lawyer, a judge is something you see on TV, and it's like, guys, it's not that simple. It's not fun. It's not reality TV. It's a lot of work. They got to make sacrifices, hard decisions. People's lives are on the line, so you got to have your best moral forward. And I think she's definitely capable of that, so. I'd be proud of her.
Thank you, you've chosen wisely. All right, with that, that is all for the record. We're gonna take some pictures.
Thank you so much, Your Honor.
All right. So I need you and your sponsor
me till 1:30 on the dot tomorrow.
Yeah, we called in, they said 1:30, we get them here at 1:30.
Perfect,
I mean Brandy.
perfect.
Are you sick?
No, but John is.
Oh, yes, influenza A,
No, he has
COVID.
COVID.
COVID?
Yeah,
Oh, that's still
Well,
a thing, that's still a thing.
we got an email from him in case review saying, hey, I just have COVID, so I'm tested positive, so I'm gone. He was in my goddamn training that I ran yesterday, near me, so I'm being
That's what I said, we can do five or something.
I'm just gotta look for the bald spot. I would say I'm short, but so I love you. Look for the bald spot. I know.
No, I need to know. I don't know if it's just a spot or.
No, it's definitely one spot.
We're getting, that's because you know what, we've been doing this a long time, that's why. We're getting old.
You gotta get going.
We used to be the young new project, we used to be the young new lawyers and now we're not. Okay, I can.
I think.
Not even that.
Yes.
You don't know that, God.
Our volume, are we up and running?
Nope, we're good.
Okay, are we on?
Yep,
Yeah.
yep, good to go.
All right, this is docket 256246FH, people of the state of Michigan versus Amanda Marie Bartkowiak. Is that how you say your name?
The W is pronounced as a B.
Oh, Bartkowiak.
Yep, now you got
Okay, thank you, now I got it. It's easy once we say that. All right, counsel, your appearances for the record.
Good afternoon, Your Honor. Natalie Maycomer on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Amanda Bartkowiak. Am I pronouncing that right?
Bartkowiak?
Bartkowiak.
Yes, thank you. And ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
I do.
Thank you. You taking any medication today or yesterday?
No.
Are you supposed to be on medication you're not on?
Last night, they gave me blood pressure medicine.
Okay. Okay. And is there other medicine you're not on that you're supposed to be on?
No,
And any sign of fever, COVID, or other illness?
no,
Have you had enough time to speak with your attorney?
yes,
All right. And I understand this is going to be a plea, is that correct?
yes,
When you are not in lockup, do you live on Bellevue Road?
yes.
Who lives there with you?
My mother and her roommate Patty and her boyfriend Eric.
All right, thank you. And are you a US citizen?
Yes, I am.
At the time of the offense you're pleading to, were you on probation
Yes, I was.
with this court or another court?
Another court.
Okay, and do you understand that by pleading to this, you could have a probation violation as a result?
He revoked my probation.
Oh, he already did that?
Yep.
Okay. And were you on parole or bond conditions on any other file? All right, very good. And I'm in receipt of the advice of rights, and I am signing that I received the plea agreement. And you'll all receive that back in just a moment, but for the record, on behalf of the people, what is the plea agreement?
Thank you, Your Honor. The agreement in this files for the defendant to enter a guilty plea as to count one. Upon successful plea and sentence, the people will
What?
move.
Count one, what?
Upon successful plea and sentence, the people will move to dismiss the habitual offender notice.
Is that full, fair, accurate, and complete?
Yes, it is, Your Honor.
Ma'am, is that full, fair, accurate, and complete?
Yes, it is.
And counsel, you waiving reading of the habitual fourth?
Yes, Your Honor.
Ask the reading of count one.
Thank you. People of the state of Michigan versus Amanda Marie Bartkowiak, case number 25-6246FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about October 19th of 2025 at 3540 Bellevue Road in the city of Wesley, Ingham County, the defendant did in count one controlled substance possession of methamphetamine, did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032B1, this being a felony punishable by up to 10 years and or $15,000 in fines. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest. This being done against the peace and dignity of the state of Michigan.
Thank you, ma'am. Did you understand what was just said?
Yes,
or
I
read? All right, so you understand possession of methamphetamine is a 10-year felony. It's 10 years and or $15,000. Any contraband that was found at the time of the arrest would also be forfeited. And I think your DNA is already on the file, but if it is not, you would have to cooperate with giving that. Do you understand that?
Yes, I do.
All right. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did you understand what you read?
yes, I did.
If you had any questions, was your attorney able to answer those?
Yes, he was.
Do you have any questions about your rights of this court?
No, I don't.
And you indicated earlier that you had taken some blood pressure medicine, and you're feeling okay today?
Yep.
Counsel, you believe she's oriented to date, time, and place, and does understand everything?
Yes, Judge.
I do as well. She's got good eye contact, body language, and has been able to converse just fine. Ma'am, as to count one, possession of a controlled substance known as methamphetamine, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No,
Did anyone promise you anything that caused you to plead other than the plea agreement?
no.
Have you pled of your own free will?
Yes, I have.
And you did so after consulting Mr. Feigelson?
Yes,
And you've been satisfied with his representation?
yes, I am.
And do you understand that by pleading, you're giving up certain rights and defenses you would have, such as the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, hold the people to their burden of beyond a reasonable doubt, and you're giving up all of that and more?
Yes, I do.
And you understand you're also giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal, and it becomes their decision whether or not they accept or want to take up your case. Do you understand how that works?
I do understand.
All right. Now, other than the plea agreement, has anyone told you what I will do at sentencing?
No.
And that's the right answer. It's not a trick question, but everybody always pauses, which is a good thing. I don't know anything about your case. When I'm fully informed, then I'll make up my mind what happens. Do you understand that?
Yes, I do.
All right, very good. Ma'am, did this offense occur on or about October 19th, 2025?
Yes, it did.
In Onondaga Township, County of Hingham, State of Michigan?
Yes, it did.
At a specific location known as 3540 Bellevue Road?
Yes, it did.
You had in your possession the controlled substance known as methamphetamine?
Yes, I did.
And how is it you came in contact with law enforcement?
They came to pick me up for my warrant for probation violation.
And at that time, because of that, they did a search of you?
Yep, yep.
And they found meth?
No, I tried to throw it out.
Okay, so you had it in your hand?
Yep, yep.
And you tried to what, throw it out the window, the door?
No, behind me.
Okay, and so it was in your possession, you got rid of it by throwing it out, and then police confiscated that?
Yes, yes.
And then I suspect there was a test which came back positive for meth, is that correct?
That's correct, yeah.
All right, so you're not disputing that, is that
No,
correct?
no.
All right, and you would also agree that it's a controlled substance and you did not have any right, entitlement, prescription, or authorization to have it in your possession, is that correct?
That is correct.
Now, ma'am, had you used it at that time or anything else on that?
Not
day?
that day I had, no.
Okay, so you are recalling these events from your own memory?
Yes.
All right, on behalf of the people, any additional questions?
No, Your Honor.
Counsel, any additional questions?
No, Your Honor.
Thank you. Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
As a courtroom, I have a courtroom.
Yes, Your Honor.
Yes, Your Honor.
Thank you. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of means. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter. The habitual fourth is dismissed in its entirety. Any outstanding warrants, if any, related to this file are hereby recalled and dismissed. All contraband seized is hereby forfeited. And we have a sentencing date.
February 11th at 9:30.
Does that meet with your schedule, counsel?
Yes, it does, Your Honor.
All right, ma'am, you're going to need to meet with probation. They're going to do a very detailed pre-sentence investigation report that we'll talk about at the time of the sentencing. Tell me about the probation revocation. They sentenced you to jail or what happened?
He revoked it, and I don't know what I thought had happened, none of it's in the computer. All I know is that I'm doing mandatory cats, and I believe that he said 180 days, but none of it's been put in the computer.
Did that just happen?
It happened, October 28th.
Yeah, well, who's the judge?
Judge Allen.
Alan,
Well, he's usually on top of that. We need to figure that out.
and my cat started 2 days after court, so, which I was happy about.
Okay, well, we'll figure that out, all right. My issue, counsel, what I was going to say is that I'd like her to go to residential treatment, but if he's ordered that, I'm not going to modify that. However, if you talk to Judge Allen and he's in agreement, she goes to residential, which I think she needs. We could coordinate that even before sentencing, as long as there's a meth-specific program that will take her prior to sentencing, and then we could do the sentencing on Zoom, if you all agree. Meanwhile, I'm simply, what is the bond is 10%, 7,500?
Yeah.
But you're not, it doesn't mean anything right now because you're serving a time for Judge Allen. So we can deal with it in February or sooner, depending on if something's worked out with Judge Allen.
Just let me do this. Our office probably did
What,
represent.
can you say that again?
I bet our office did the probation, but I just have to figure out what
Right.
happened there, and then depending on what happened, if he's
Okay.
still serving a sentence, then we'd have to get her into treatment, and then we'd have to go talk to Judge Allen or get placed.
Yeah, so you guys can all stipulate unless the people disagree, but I think she needs inpatient residential mass specific program. So if we can do that, if you all stipulate to that, we'll do that and take the necessary steps. Meanwhile, you just participate in CAS, AA, NACA, what you're doing in the jail. Are you getting everything else you need, okay?
Yep.
All right, so.
And with the cats, we're waiting for it to go into the court system so they can help me get into treatment. Because I didn't ask for it.
All right, well, maybe your social worker or somebody can call over to Alan's office because that's unusual. It's gotta be an oversight. That's too long. I was
wrote
a
him a letter.
judge, yeah, I was a judge over there. The staff's very good. They are actually exceptional. They put things in right away. So something got messed up.
That's what I figured, because I
Yeah.
wrote him a letter last week when my mom ended up in the hospital, so I've been waiting to hear from him.
Judge, I have an update, because
Okay.
apparently our office represented her. I believe there was a hearing in September, is that correct, Amanda?
Yeah, it would, yeah.
The probation got extended a year.
Okay,
That's what our office indicated.
And
Okay.
then,
so is she in,
I believe this is our only case that's holding her. I believe.
well, let me just say this, if you find that there is a bed open for a meth-specific program, I will sign an order that she can, she must attend that, she'll get a PR bond upon transport, she has to comply with all conditions and sign all releases and then report to probation within 24 hours, but I want a long-term residential treatment, none of this 10-day, 20-day. This is I want at least a 90-day program or longer. Any problem with that?
No, Your Honor, I just want to let the court know, according to the jail website, she does have a hold for that probation violation out of 55th, but also a hold out of Jackson County.
Okay, so when we clean all that up, that would be what I would order, but we gotta clean all that up. Okay, ma'am, you need to be in treatment, get all that stuff cleaned up, okay?
yes,
Okay, so keep me posted and then we'll work on this.
all right,
I just think we should do it sooner than later.
thank you.
Hopefully, that's managed for the next couple weeks.
All right, thank you. All right. Jackson, we do have
We are-
MDOs.
We're not going on the record on Jackson's, we just signed what we needed.
Oh, we did?
Your Honor.
Okay,
We're gonna complete it, Your Honor, we're all set.
great, thank you. Then I
Judge,
need
if you want to
MDOs.
take McGrath, that's the
Yes,
FDOC one,
thank
that's
you.
my case.
Thank you.
I think there's a
Thank you, Your
witness
Honor.
here as well. So motion for against their hearing, Judge.
All right, this is. All right, this is docket 24241 FH, People of the State of Michigan versus Reed Francis McGrath. Counsel, your appearances for the record.
Elizabeth Allen on behalf of the people, Your Honor.
Good afternoon, Your Honor. Don Birch appearing on behalf of Reed Francis McGrath, defendant appellant, who is on Zoom from his MDOC location.
All right, so.
Is it the JCS or the IBC?
JCS.
Okay.
Record should reflect he is present. We're asking to unmute, but I don't see, are you allowing him to unmute?
Yeah, I'm asking too.
So I don't see that he's unmuted, but I don't know that he's gonna have anything to say in this motion anyway. I want to just make sure. Can you hear us, sir? Oh, there you are. Sir, please raise your right. Sir,
So
please
they're
raise your right.
They wanted
Do you-
to, it's 2:30, so I don't know why.
Do you swear, sorry about that. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. I don't know that you will have anything to say, but just in case, I've sworn you. This is defendant appellant's motion for your third hearing, counsel.
Yes, thank you, Your Honor. So, Your Honor, I brought forth this motion. I'm requesting a get-there hearing to support my client's claims of ineffective assistance of counsel. And then, if that hearing is granted, then the outcome would be to afford him the ability to withdraw his plea. And Your Honor, I'll just be brief, because I know that you have read the pleadings. But Your Honor, I stated the reasons that trial counsel's performance fell below an objective standard of reasonableness for the following reasons. Number one, the trial counsel failed to investigate the facts regarding the execution of the warrant. Mr. McGrath insists that the warrant did not allow the police to search his phone. And speaking on that, Your Honor, I got from the prosecutor in the response and the affidavit for a search warrant. And it says the person, place, or thing to be searched is the residence and then the vehicle. Well, the phone was found in the vehicle tucked away. And then it says also the property to be searched for and seized is if there was evidence of the crime of breaking and entering, larceny in a building, but not limited to photos. And Your Honor, this all stemmed from a breaking and entering case that he had and was convicted in Eden County. But the search warrant does not state that they can seize the phone. And so that is my argument that trial counsel should have filed a motion for illegal search and seizure to suppress the evidence from the phone. My client states that he talked to his defense attorney about it, but the defense attorney stated that filing a motion would do no good.
Well, sir, why hasn't there been a motion to withdraw the plea filed before this court? Doesn't that come first? Isn't this the cart before the horse?
Well, not really, Your Honor. I am asking, withdraw the plea based on ineffective assistance of counsel. But then, of course, that's got to be proven at a Ginter hearing that there was ineffective. Now, I had just presumed that asking for a Ginter hearing means, of course, that one, the outcome is to withdraw the plea. Now, I'm orally arguing it, but that's the outcome of that.
Okay, thank you. Response?
Thank you, Your Honor. That was initially my first point in my response as well, is that we don't just have a Ginter hearing for no reason. A Ginter hearing is accompanied by a motion to withdraw a plea, a motion for resentencing, and a claim that there's something that we're going to, the court is going to rule on, and therefore we can have a Ginter hearing. But even if we look at this motion as a motion to withdraw a plea and request for a Ginter hearing, it's our position that there was no basis for a motion to have been filed, and so trial counsel was not ineffective because trial counsel is not ineffective for failing to raise a meritless motion. In this case, this defendant, first of all, was on probation out of Eaton County for accosting a child for immoral purposes and indecent exposure. And so he had an order of probation, as I attached to my motion, that said the probation agent could, with reasonable cause, search and seize any of his property, okay? If he's
That
had
would
a-
include the phone.
That would include the phone. And in this case, this defendant was arrested for breaking and entering a building to steal women's underwear. And as part of that, as we attached to our motion in the DVD that includes the full interview, the waiver of Miranda rights, he admitted, in addition to the crime he was arrested for, that he had photographs of children on his phone and that he had been engaging with children under age 17 or under. And so at that point, his probation agent, as you can see in the video, is on scene during the arrest and during the interview. So it's our opinion, to begin with, this phone was going to be seized and searched. The defendant admitted to 3 different violations of his probation, specifically engaging with children, having photographs of children on his phone, and committing a new crime. But outside of that, in this case, when the police go, first they have a search warrant to search the house and the vehicle, which they did. And when they find that phone under published case law, People versus Evans, they had the right to seize it. They didn't seize it and just search it. They seized it because the defendant's being arrested, his mother was home. There's ability to have access to that phone via the internet to delete anything that's on it. So when the police are arresting him and have a valid search warrant for his vehicle, they can seize that phone. And then as we go, and as I attached in our attachment 4, he fully and unequivocally consents for them to search that phone. He gives them the passcode, he signs the consent to search form, and while defense counsel says, my client states this, nothing has been stated by the defendant. There's no affidavit, there's nothing that says what did or did not occur between him and his counsel, or any actual claims of coercion. And everything that we have sent to this court shows that the defendant freely and voluntarily consented for his phone to be searched. But even if he had not, he was there with his probation agent, and that phone was going to be searched because he was admitting to 3 different violations of his probation, including having contact with minors, having photos of those minors on his phone, and then committing a new crime, which had a sexual component, which was breaking and entering into a building to steal women's underwear. So under all 3 of those different versions that I gave you, there's reasonable cause for the police to seize the phone and then consent to search the phone. So for trial counsel to file a motion would have been meritless. And so we're not going to then go back now, that's a matter of strategy. Instead, trial counsel got him a plea rather than waste time, because the defendant is in the Michigan Department of Corrections, as this court can see. And if this court recalls, when he pled guilty, he was also in the Michigan Department of Corrections. So he was not getting credit, he was sitting on dead time. So instead of filing a meritless motion that's going to have his client sit for how much longer, he got him a plea deal that allowed him to serve concurrent MDOC time with his current sentence and not go any further past that. So that was effective trial counsel decision-making and advocacy, and we'd ask you to deny this motion.
Thank you. Final word, your motion.
Your Honor, the prosecutor argues that the phone would have been seized, but then again, that is hypothetical, would have been seized. And so, Your Honor, I think there was a good argument that the defense attorney could have made for, hey, it was breaking and entering. There was no reason to take the phone and to seize it. And then, of course, my client is called into the interview, and of course he's nervous and he feels like he's coerced. He told me he was coerced into signing that. And so, Your Honor, I respectfully ask that you grant the motion for a Ginther hearing.
Well, first of all, let me just be very clear. Next time, file the motion, withdraw, and then get their hearing. But as it stands for judicial economy and all our sakes, I am going to deem this a motion to withdraw plea as well as the motion for Ginther hearing and deny both. for the reasons stated by the people, but specifically, I agree that this was a trial strategy. He got a great plea deal, and I think this is more in the category of buyer's remorse. And consent was given, he gave the passcode, there was probation waiver, he knew what he was to do and not to do on probation, he didn't care. He wanted to do what he wanted to do, which is not unusual for the kinds of cases that are similar to this. There is something that drives these people to want to do this. This kind of behavior, and he needs the time in the Michigan Department of Corrections to hopefully be rehabilitated, because this is very serious, and he admitted to the CSAM, so I don't see any grounds for this. I think you've laid enough grounds for further appeal if that's what you want to do, but I don't see any grounds to grant anything except to reaffirm what's already been done.
Okay, thank you, Your
Thank
Honor.
you. It's all for the record.
I'll set up a meeting with you, Mr. McGrath, here next week or so.
Yeah, I saw that in it also.
All right, next matter. Mr. Goodrich?
Mr. Brainerd.
All right.
Your Honor, may I approach with an advice of rights in a plea agreement?
Please.
Is it Brainerd? Brainerd, yes. Got it here.
All right, court has signed the agreement. We're going to give you copies. This is docket 255564 FH, People of the State of Michigan versus Parker Omar James Brainerd. Counsel, your appearance for the record.
Good afternoon, Your Honor. Natalie Maycomer on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Brainerd, who was standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the coming of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
I'm not supposed to be on no medication at all.
Good. Any sign of fever, COVID, or other illness?
No,
Have you had enough time to speak with Mr. Goodrich?
yes,
All right, very good. And do you still live on Clifford?
Cleveland.
Cleveland? Okay. Do we have that address on the device? Right?
Yes, there is an
Okay.
address on the device.
So we have the address change. Thank you.
1022.
All right, very good. Thank you. And are you a US citizen?
Yes, Your Honor.
And are you employed?
Yes, Your Honor.
What do you do, sir?
I'm a concrete finisher at Chapman and Sons Concrete Company
Okay, good,
out in Byron, Michigan.
good. And the offense that you're pleading to, were you on probation, parole, or bond conditions on another file?
I'm on probation through Shawwassee.
And so will this plea result in a possible probation violation?
Yes, it will.
And you're aware of that, sir?
I'm still, my PO wanted me to wait for everything to go through with this court.
I understand that, but you're aware.
Yes, sorry.
Yeah, I just need to make sure you understand all the possible penalties by doing
Yes.
this plea. So you talked about that with Mr. Goodrich, and you know.
Yes.
All right, very good. And you wish to proceed?
Yes.
All right. On behalf of the people, what is the plea agreement?
Thank you, Your Honor. The agreement in its files for the defendant is a guilty plea as to count one. Upon successful plea and sentence, the balance will be dismissed. Further, there is a sentencing agreement to no further upfront jail at the time of sentencing, so long as he agrees to probation.
So long as he what?
Agrees to probation.
All right, thank you. Full, fair, accurate, and complete.
Yes, it is, Your Honor.
Full, fair, accurate, and complete.
Yes.
And counsel, you're waiving reading counts 2 and 3.
Yes, Your Honor.
As to reading count 1.
Thank you, Your Honor. People of the state of Michigan versus Parker Omar James Brainerd, case number 25-5564FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about August 22nd of 2025, at Porter Street and South Pennsylvania Avenue in the city of Lansing, Ingham County, the defendant did in count 1, weapons carrying concealed, did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, to wit, a Dodge Charger, contrary to MCL 750.227. This being a felony punishable by up to 5 years or $2,500 in fines, mandatory forfeiture of the weapon or device. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest. This being done against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
And so you understand count 1, weapons carrying concealed is a felony punishable by 5 years or $2,500. There's mandatory forfeiture of weapon or device. Any contraband that was seized, you will not be getting back. Do you understand that?
Yes, Your Honor.
All right. And I don't know, and I'm sorry if I just don't recall, but the habitual second was being dismissed, correct?
Yes, Your Honor.
All right. And sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
The rights form that talked about, that you're not gonna have a trial.
Oh, yes.
Okay. And did you understand what you read?
Yes.
And if you had any questions, was Mr. Goodrich able to answer those in regard to your rights?
Yes.
Do you have any questions about your rights of this court?
No.
Sir, as to count 1, weapons carrying concealed, how do you plead?
Guilty.
Did anyone force, threaten, or coerce your plea?
No.
Did anyone promise you anything other than the plea agreement to plead?
No.
Have you pled of your own free will?
Yes, I have.
You did that after speaking with Mr. Goodrich?
Yes.
And you've been satisfied with his representation?
No. Oh, have I been satisfied?
Yes.
Yes, all right.
All
Sorry.
right. I'm surprised that no.
I can't hear, I'm already hearing
Everybody loves being represented by Mr. Goodrich.
I have an ear infection right now on my right ear.
Oh, I'm
so-
sorry. Do you need a?
No, I'm good. I'm good. I can
Okay,
handle
we'll
it.
just make sure. Okay, thanks for letting me know. You might want to take some medicine.
I am.
Okay, okay. And sir, do you understand that by pleading, you're giving up your automatic right of appeal? So if you had a bench trial or jury trial and you were unhappy, the Court of Appeals must take up your case, but now it becomes their decision. So if you want to appeal, you first have to ask permission, and they will only take up your case if they think your issues are important. Do you understand that?
Yes, I do, Your Honor.
Now, has anyone told you what I will do at sentencing?
A what?
Has anyone told you what I will do at sentencing?
No.
Because I don't know. When I'm fully informed, right now I know very little about your case. When I'm fully informed, then I'll make up my mind. Do you understand that?
Yes, I do, Your Honor.
All right. And there is a recommendation for no upfront jail at sentencing. So if I gave you some jail time at sentencing, I would allow you to withdraw the plea, and this matter would again go to the pretrial stage. Do you understand that?
Yes, I do, Your Honor.
However, if you violate bond or bond conditions of the law between now and sentencing, I could put you to jail and not allow you to withdraw the plea. Do you understand that?
Yes, I do, Your Honor.
All right. Sir, did this offense take place on or about August 22nd, 2025?
I don't remember the exact date.
Was it the end of summer, possibly in August of 2025 this year?
Possibly. It's been a couple months. I work so much. I don't.
Okay, but you're not doubting, if the felony information says August 22nd, 2025, you're not doubting that, is that correct?
Well, it sounds about right because it was right before my birthday. It happened right before my birthday. My birthday's in September. So it was right before my birthday.
Okay, well, happy belated birthday, so you're not disputing that.
No.
All right, very good. And was it in the city of Lansing County, in the state of Michigan?
Yes, Your Honor.
And you came in contact with law enforcement at a specific location known as Porter Street and South Pennsylvania Avenue?
Yes, Your Honor.
And why were you in contact with law enforcement? Were you in a vehicle, walking, on a bicycle, something?
I was just on my way to the store.
In a vehicle or what?
And the Charger, the Dodge Charger I was in,
Okay, are we the driver or passenger?
driver.
And why did they pull you over?
I pulled into Eric's Market on Pennsylvania, sat there, and I noticed two state troopers pulled in across the street. So I'm like, okay, that was kind of weird. And then I just pulled right out, and then I pulled out, and they got right behind me and pulled me over. They said it was because of my tent, but it was like, it was just my tent. Why didn't you just pull me over inside the parking lot? But I don't.
Mr. Goodrich, are you challenging the stop?
No, Your Honor, that would be a civil infraction that would grant the officers the ability to pull
All right, and, sir, they talked to you about the tent, how is it they came to find the weapon?
I had no insurance on the vehicle, so I gave them probable cause to search it. Some about inventory search.
Okay, and they did it right there, did you give them permission to search?
They didn't even ask me.
them. Your Honor, with there being no insurance on
Insurance,
the,
yeah, but
there was no insurance on the car, correct, which meant that the officers had to have the car towed at that point.
yes.
And as a result of that, they conducted an inventory search of
Is
your
that correct,
vehicle.
sir? Yes? Is that
Yes,
correct?
yes.
Okay.
I was letting them talk.
Okay.
That's fine, I just need you to agree with what he's saying. So, as a result of that inventory search, they end up finding a pistol, it was your pistol?
So it's my aunt's
Okay.
pistol. She left it in the car when I picked up. I just picked my car up after getting it fixed.
I just picked my car away.
I picked my car up after getting it fixed. I got a brand new drive shaft on it. I don't have the car no more though.
Okay,
And I dropped her off at home. She forgot, I noticed she forgot her pistol at the time when I went to the store, but I wasn't caring. I'm not gonna sit here and lie to you, I didn't care. So I wasn't thinking, but then I did call her and I did tell her.
okay.
I was gonna take it to her and then it just, like I said, it all happened right then and there.
But you understand that having a record, you
I
can
do.
have it, and so you should just,
And that's why I'm accepting my consequences now.
okay. You're not the only one this happens to, sir, so, we see a lot of this, you just gotta be
I got two
vigilant.
kids, I'm tired of getting in trouble.
Yeah, you gotta be vigilant, okay, so where was it in the vehicle?
The passenger seat, the passenger seat.
Okay. And you would agree that you were not eligible to have a pistol because you've been convicted,
As a felon?
as a felon?
Yes.
All right, and you would also agree that a pistol is a dangerous weapon?
Yes, Your Honor.
Now, your aunt, does she lawfully have this pistol?
I don't know if I don't talk to her like that. Like I only see her when I go see my mom. So I don't know if she got a bag or what.
Well,
But she said she called up there and let them know it was hers and everything. And
okay, the reason I ask is because the weapon is forfeited as to you. If she is a lawful owner of it, she may pick it up.
right.
Okay, if she's not, then it's forfeited regardless.
Okay.
Does that make sense?
Yes, yes,
That's
ma'am.
why I asked you. Okay. On behalf of the people, any additional questions?
No, Your Honor.
On behalf of your client, any additional questions?
No, Your Honor.
Are counsel aware of any promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does the court comply with the court rule?
Yes, Your Honor.
Yes, Your Honor.
I find defendants pleas been freely, voluntarily, knowingly, and understanding made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter, counts 2 and 3. And habitual offender second offense notice are hereby dismissed in their entirety. Any outstanding ones, if any, are also recalled and dismissed. Do we have a sentencing date?
February 11th at 10 a.m.
Meet with your schedule, counsel?
Yes, Your Honor.
All right, sir, you'll need to make an appointment with probation. And that's, while you're in the building, just go downstairs and make that appointment. Otherwise, the phone number is on that purple sheet that you're gonna get in a moment. It's 517-483-6100. Bond conditions are continued. If you fail to do the pre-sentence investigation report, that can't proceed to sentencing, so you'll be arrested and sit in jail and get it done. that way.
Pre-sentence, what is it?
It's a pre-sentence investigation report.
We'll walk down there after court.
All right,
Okay.
so if you want to shorten up probation, because you said you're tired of all this, use this time you got, I don't know, 6 weeks or so, to do a weapons safety class.
I will. I planned on it.
Great. And then you don't, Mr. Goodrich can talk to you about it, you don't have to, if you do it online, you don't have to download the form, you can take a picture of it. He can talk to you further about that, but
Okay.
if you completed it, it will shorten your probation, okay?
Okay, thank you.
Merry Christmas, thank you.
Merry Christmas too.
Next.
I saw another him last week and he was.
It's been the whole year.
Wilson and Ramos. I have Bill Wilson and Ramos. Yes.
Where's that? It's still here.
Hello.
We're returning just a moment.
All rise.
Oh, yeah, no, sorry.
Good. No, I'm sorry.
Where did you have the key?
In the back.
Doesn't matter. That doesn't change that, she's still here. I know Judge is gonna get out. I was worried that I might have passed and she was gone.
No, she's.
I was wearing a black wig just a few minutes ago.
Were they able to fix the issue and get us a picture on there?
It's very comfortable.
Which one?
Very happy.
Well, we got Timothy Pitcher, who's supposed to be an MDOC. I am assuming IPC Unit 4 is him. And
It's a
they're,
little frozen
yeah, it's been that for the last 30 minutes.
because somebody's got too much time.
Well, thanks.
Again, if we all just throw things at Brian eventually.
I just wish it was all cotton. It was all cotton, you know, they cool fitting with like the India suit, you know?
Yeah.
I think it's that.
Yeah, we like him too.
As soon as they're out of chambers, I'll talk to Brian and see if they can get that working, because otherwise, we'll get a new date, we'll get for as soon as humanly possible, we'll handle it then.
Get black. I think they're actually there.
By the way,
Yeah, they're there, still waiting on a few more things.
And I got such a lovely example here to use.
At the Taylor, so
From
I
yesterday.
probably should go with them. but-
Where are you guys with the new model 45?
Yeah.
Hypothetical.
Okay, I'm just throwing it out there now. I didn't realize you
It's a
still.
little bit
for the
longer
comments.
than the 19.
Yeah, well, unless we decide to. Not say Let me tell you.
You wanna hold it?
Hey, not moving.
Yeah, no, I saw it.
That person there.
Hey, are we currently muted?
We
Courtroom
are
here?
not currently.
Because that is.
All right, we are back on the record. This case now is docket 25-3251 FC, People of the State of Michigan versus Tashara Monique Lynch. Counsel, your appearance for the record.
Your Honor, thank you on behalf of the people, Assistant Prosecutor Bill Prino.
Good afternoon, Your Honor. Lana Woolley on behalf of Mr. Cheryl Lynch. She is present and seated to my left.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury? Yes. Thank you. Put your hand on. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had an opportunity to speak with your attorney?
Not yet.
Did you want some time to speak with him today? This
Well,
is a bond motion.
Well, yeah, before this.
Okay, all right. So we're ready to proceed. This is a motion by defense counsel for bond.
It is, Your Honor. Thank you. Your Honor, prior to this hearing, I did submit a motion for bond reduction here. As the report indicates, my client's been in jail for, it'll be a year pretty soon. And while at the jail, she's completed a bunch of courses that's offered at the jail. And also, this is a 5 co-defendant case, and I want to let the court know that that I disagree somewhat with the draft of the report, in that there are things that could assure appearance in court and then make sure that the public is safe here. In that 3 out of the 4 co-defendants in this case have already been able to post bond, and have not heard anything as far as there are any issues with their bond. So there are conditions that has been able to be reached to keep the community safe with those 3 co-defendants, and also assuring their appearance in court. In my client's favor, she has no prior criminal history. She's availed herself to all the courses, as I said, and there are no reason to believe that she would not make it to court, as this is her first ever criminal incident. And also looking at the form that I think most county uses, she is a low risk in that. But yet the drafter of the report asked for a deviation and that the bond be denied. Currently she does have a bond set, but however, Your Honor, she has been unable to meet that bond. It's very high, and she does understand why she's here, and she understands what happened here. So we're not saying that she is disputing the facts or saying she wasn't there at all, but rather to take that into consideration, that but for her income level as compared to the other three at the very least, she's unable to post a bond. So that's the only difference here. So I think if you were to grant her with a GPS debtor or even homebound, she can only leave her house to go to a doctor's appointment, which she'll have to clear with pretrial services, or to meet with me, again, she would have to clear with pretrial services, that she'll be meeting with me, and then my office is online, they'll know exactly where she's going to be, and they'll be able to follow her from leaving her house all the way to my office where we would be meeting, and once our meeting would be concluded, she'll return back at home. So at this time, Your Honor, I know it's like $250,000 or what it's set right now. I'm asking for about 125,000, 10%. And I think that's a huge amount, just so that at least her family could put together some of the funds, although it's not their responsibility, but they also want her to be home and allow this young lady to go home pending trial or resolution of this matter. Thank you, Your Honor, for listening.
Thank you. Counsel?
Your Honor, thank you. This is the third consideration of bond for not only this defendant, but all of the 5 charged co-defendants in this very serious homicide case. Initially, the defendants collectively were given a $100,000 cash surety bond prior to the victim dying in this case. When the victim passed, the case was dismissed and reissued as a homicide. At that point in time, all 5 defendants, to include this defendant, were on a no bond hold. After the preliminary examination, or I should say during the course of preliminary examination, the district court judge reduced, after extensive argument on all of the bond factors, each defendant's bond to $250,000 cash surety. And it's our opinion that a very lengthy and detailed discussion of all the bond factors applied at that hearing, and that nothing has really changed between the time of that initial bond hearing and today. The most important factors we believe for this court to consider, Your Honor, is the defendant's risk of non-appearance, given the fact that she's charged with open murder. It's our position that this would be a first-degree murder conviction, and there is a potential for a life without parole sentence. Additionally, her risk to the community, and there was a pretrial services recommendation made by Ms. Nicole Ginther, and she indicated, as the court is aware, Your Honor, that there are no conditions or combinations of conditions that would first assure the defendant's appearance in court or would protect the safety of the community. So looking very much at those 2 factors, it doesn't appear that any type of bond deviation is appropriate. And in fact, pretrial services ask that the deviation be denied. So we will leave it in the court's discretion, understanding all those facts. Thank you.
Do we have a next date for pretrial, final pretrial and trial?
We do, Your Honor. I don't know the date of the final pretrial. It's sometime in February, and then we have a trial date set for all 5 co-defendants, I believe March 3rd. There may be some changes as to what defendants go on that date. Joinder and severance is still pending. That's a pretty tall order to try 5 people at one time. Most likely we'll try a combination of these people, but the first trial date will be available on March 2nd.
March 2nd or 3rd?
I'm sorry, March 3rd, Your Honor.
Okay, and the final pretrial is in February?
I believe we put, I don't have the pretrial order in front of me, but it's sometime in February. Yes.
Okay.
March 3rd to Tuesday.
I just learned March 3rd is a Tuesday.
March 13th.
March 13th.
It's March 13th.
Oh, I'm sorry, March 13th.
Okay, just making sure, okay.
And Your Honor, just to add a few comments here, when we did the last pre-trial, we did that via email. And then subject to the trial date being moved, because I do have a trial currently scheduled for the time that this trial is currently scheduled as well. That was scheduled before this one in Berry County.
Okay, well, we'll figure that out as we go forward. Anything you want me to know, ma'am? Without talking about the case?
Like you said, I've never been in trouble before. I don't know if you looked at the details of this case, but it is for me, It is a matter of wrong place, wrong time. And, since I've been in the jail, I've taken up all the programs. I've got all my certificates. I have really been trying to utilize my time wisely and understand where I went wrong in this situation. And I just ask that you let me be, get a chance to be home with my family before sentence or trial.
I will reduce bond. I'm not going to release you on a PR bond. I don't think that's right, with the kind of charges. I also think poverty should not hold you. The other people can post a bond, so I'm going to make bond more palatable to you should you be able to make this. And certainly council can readdress this issue as the case moves forward, especially if there's delays. But for today's purposes, instead of having a 250,000 cash bond, you'll have a 250,000 10% bond. You'll report to pretrial services weekly or as directed, and it will be with a jail GPS tether. You will not use, possess, consume, purchase, or be in the presence of illegal drugs, alcohol, marijuana, or drug paraphernalia. If you have a need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You'll take any psychotropic medication as prescribed. You will follow all your doctor's orders. You will not own, have in your possession, or under your control any weapon, gun, ammunition, nor be in the presence of weapon, gun, ammunition, or imitation of a weapon. You'll not use any object as a weapon. You will not be in the presence of any known gang members. You'll not wear any gang colors, insignia, or gang tattoos. You'll maintain your residence, and any address change will be reported to pretrial services, the court, and your attorney within 24 hours. You will also be under house arrest should you make bond, and only leave for work, school, medical, court, and to meet with your attorney. You will appear for all hearings and proceedings. There is a February, apparently, final pretrial date. We will provide notice of that to you, or your attorney will, and there is a March 13th trial date. Again, I don't know if it's your case or any of the co-defendants, but you need to appear for all hearings and proceedings and work with your attorney on those dates. They may fluctuate, as he just indicated that he has a conflict. So you'll also not have any contact with any witness or victim. Anything else I need to order?
Nothing for the people, thank you.
Thank you. You receive a copy of this. Next matter.
We have one more scheduled, we have one more scheduled final pretrial and two more scheduled final pretrials.
You know that?
Yes.
Okay.
Are you sure?
Yes.
Unlike yesterday?
Yeah.
This is yeah, I'm sure it is time.
All right, this is docket 25-4206 FH People's State of Michigan versus Dominic Ramo. Counsel, your appearance for the record.
Good afternoon, Your Honor. Natalie Maycomber on behalf of the people.
And thank you, Your Honor. Jonathan Foreman, Office of Public Defender, here with Mr. Ramo, who is standing to my right.
Please raise your right hand. Do you swear or affirm that testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the truth is perfect?
I do.
Thank you. Put your hand up. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication? You're not on? Any sign of fever, COVID, or other illness?
No.
All right. And you had enough time to talk with your attorney?
I have, yes.
All right, just a moment. All right, sir, do you live in Flint on Maplebrook?
No longer.
All All right, and do we have your,
You put it on the vice form, you don't have this updated address.
thank you. All right, and have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not?
No.
Any sign of fever, COVID, or other illness?
No.
Was this offense committed while you were on probation, parole, or bond on another file?
No.
And you're a US citizen?
I am.
All right, very good. What is the plea agreement?
Thank you, Your Honor. The agreement in this files for the defendant to enter a guilty plea as to count 1. There is no objection to HYTA status as the defendant was 18 at the time of the offense.
Okay, then we are not, we're in a, I guess we're in a closed courtroom. We need to close the Zoom room. HYTA is granted now, so we will close everything.
What happened?
She's
Four
bragging.
hundred forty-four words a minute. I mean,
Nancy's humble bragging.
I'm humble bragging. You're right.
Who
I have no idea.
It was Foreman.
I like that.
You made Nancy work.
Wasn't it, look, come here. Wasn't it?
I thought it was going fast today.
The appellate, look.
No, didn't the appellate attorney, someone else went faster today.
How many, that's words per minute, but it could have been like it. For 4 seconds or something. I don't know, but I'm.
It's okay, we're gonna give him a delayed traffic ticket as soon as we find
I was told you were going fast.
There you go, you got your traffic ticket. Give him his traffic ticket, Mr. Foreman,
Oh.
So this is.
your traffic ticket.
You want one? Here.
Just the two of us.
It's-
Hey,
look
not
at-
me today,
for the
telling you that.
record, what's the world record? No way could I ever.
There are some attorneys who have several of those framed on their wall.
I paid my get off. Your turn.
But we didn't even know.
You are in custody.
All right.
We didn't have anything.
Are we ready?
We are.
No, is this
Ready.
one on?
Yep, it is, he's on, we're ready to go.
It is, Your Honor.
Okay, so you can unmute. Sir, can you unmute? Great. All right, this is docket 25241 FH, People of the State of Michigan versus Timothy Lee Pitcher. Counsel, your appearance for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Your Honor, good afternoon. My name is Keith Watson. I'm the public defender. I'm here today on behalf of Timothy Pitcher. He appears remotely from the MDOC in a hearing room. And if I understand correctly, he can see and hear us, and we can see and hear him.
All right, I can see him. Let me see if we can hear him. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. You put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And have you had enough time to speak with Mr. Watson?
Yes, ma'am.
All right, counsel, what are we doing here today?
Your Honor, today is the date and time for final pretrial conference. The parties believe that we have worked out a plea agreement in this matter. We would ask this to be set for a plea hearing and one where the defendant will be here in person, so that way communication between him and his counsel can be less cumbersome. Let's put it that way, because I know defense attorneys having to communicate with their MDOC clients is very, very challenging, given the MDOC.
So you're going to do a writ?
Absolutely, I'll have it done today.
All right, and so what date are we looking at? Do we have an opening?
How far are we going?
Counsel, how far are we looking at? January, February?
Sooner would be better, Your Honor. He's on dead time. So if we can find one in January, that would be great. I do not know the court schedule.
Do we have a January date?
As soon as we got to 11.
February? Yeah. Can you give me a January plea date? Is it January 15th at 10:30 work?
We'll make it work, Your Honor.
All right, they're gonna make that work. Then this will be the Pitcher case. Thank you. We're in our books. Anything else we need to address today?
Oh, yes, Your Honor. Mr. Pfeiffer was very kind in his language choices when it comes to it being cumbersome for a defense attorney to consult with a client who's in the MDOC. I should note for the record that I tried a couple of weeks ago to have a meaningful consultation again with Mr. Pitcher. That time via the remote system that the MDOC provides. I spent about 45 minutes in the waiting room, having appeared at the appointed time. Thereafter, I was bounced out of that waiting room and could not get back in, could not then consult with Mr. Pitcher to have a consultation, just to try to keep him informed as to what has transpired. Since that time, an offer has come from the people, and then most recently, even today, a more attractive offer has been made by the people. I would ask that Mr. Pfeiffer might place on the record, as long as we have Mr. Pitcher present here, so we're all on the same sheet of music, so he doesn't feel in the dark. Today, when I tried to consult with him in the breakout room, thanks to the efforts of Your Honor's assistant, I was able to have a consultation with Mr. Pitcher, be it ever so brief, but that even too was interrupted by stalls in the system, making it being muted at different times from his end. And it was, that even itself was difficult. I'd like Mr. Pitcher to at least have the comfort of hearing on the record today what the very most recent offer is today. And part of the reason as well why it is I asked to be set for a date tentatively for plea was so that I could have opportunity to consult in a more meaningful way with Mr. Pitcher.
Thank you. What is the offer?
The offer is for the defendant to plead guilty to count 4, assault with a dangerous weapon, count 5, aggravated domestic violence, and count 6, normal domestic violence, as an habitual third offender with a sentencing agreement to 2.5 years as a fixed minimum. The people would agree to dismiss the remaining charges and any restitution would be included.
Naturally, Your Honor, because we only received this offer and because of the difficulties in communication, I don't believe Mr. Pitcher is in a position to accept or to reject that offer today that was only made today.
All right. So, sir, you'll have some time. You're gonna come here. You'll have some time to think about it with your attorney and discuss it when you come here as well. And then we'll see if we proceed to plea. Is that all right with you?
Yes, ma'am.
All right. Anything else for the record?
Only that I'm sending the email for the writ to be done right now.
Great.
So that way we can ensure that it is done and he's able to be here in person.
If he is not brought over and they receive the writ, we will immediately do a show cause for contempt because their track record is very poor. Just so everyone's aware.
Very thankful, Your Honor. Thank you.
Thank you. Merry Christmas. That's all for today's record.
Thank you.
Thank you, Your Honor.
Are we done or is there anything else?
One more.
for today? See, you told us.
I said, I think, Judge. And you know where we take
I
our,
think doesn't count.
you know where we take our beliefs to.
We've warned you about thinking before.
Yes. All right, so we have Mr. Wilson. Is this a final pretrial?
Yes, Your Honor.
Okay. Is he in lockup?
Yes, Your Honor.
This is.
I'm bringing him out right now.
You said Wilson?
Yeah, it's the very first one.
Oh, here we go.
Do we have?
He fucking is on our phone.
Wasn't him, there's somebody else out there.
We're done with this one, right?
Yeah, I'm removing it.
This is docket 23-266 FH, People's State of Michigan versus Duran Maurice Wilson. Counsel, your appearance for the record.
Good afternoon, Your Honor. Natalie Maycomber on behalf of the people.
Good afternoon, Your Honor. Melissa Patrick on behalf of Mr. Wilson, who is here to my left.
Mr. Wilson, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury? Thank you. Put your hand down. Sir, have you taken any medication yesterday or today? Is it anything that would affect your ability to understand the court or your attorney? Ms. Patrick, please put the microphone close to him. Is there medication you're supposed to be on that you're not on? Any sign of fever, COVID, or other illness? And you had enough time to speak with Ms. Patrick? All right, very good. This is the date and time for a final pretrial. It's taken a few tries to get everybody together. What is the offer?
Thank you, Your Honor. The offer currently in this file is for the defendant to enter a guilty plea as to counts 1 and 2 as a habitual offender, second offense. The people would dismiss count 3.
Is that full, fair, accurate, and complete?
It is, Your Honor. Count 3, and I believe the second notice for the domestic violence.
And was the victim consulted?
Yes, Your Honor.
And what about, there's also a count 4?
Rosemarie, yes, we dismissed that as well.
So you dismiss the HAB third, count 3 and count 4, and you plead to count 1, 2 with the HAB second.
Yes,
Okay, now is that full, fair, accurate, and complete?
It is, Your Honor.
Is that full, fair, accurate, and complete, sir? Is that your understanding as well? Do you understand?
Yes.
All right, and Ms. Patrick, will there be a plea or will there be a trial or what's going on?
I spoke with Mr. Wilson downstairs and I had went to see him previously down at the prison in Jackson. At this point, Mr. Wilson wants to leave this case on for trial. He's gonna speak with his family about the finances involved with that, but he wants to leave it on for trial for sure.
Okay, so that's perfectly fine, sir. You have a right to a trial. Is this a decision that you made on your own? Did anyone force, threaten, or coerce you to make this decision? Did anyone promise you anything that caused you to make this decision? All right, and you made this decision with your attorney? And you've been satisfied with the representation of counsel? Are you happy with your attorney?
Yes.
All right, well, we're gonna put this, or leave this on the trial docket. When is the trial set for?
February 6th.
All right. All right, I'll see you February 6th. Are there any special motions that need to be filed?
Not at this point, Your Honor. I just wanted also to let the court know that if it's, in speaking with Mr. Wilson, if it's not possible that he can afford a trial and.
Well, what do you mean not afford a trial? Are you court appointed?
No, I'm not, Your Honor.
Okay, so if he can't afford a trial but wants one, then he can have court appointed counsel. And then that needs to happen very quickly because in this kind of case, there's a lot of preparation, as you know.
Yes, Your Honor, and I have explained it.
Okay, so we can appoint you, sir, court appointed counsel. I can tell you that the judges review the attorneys regularly, so we make sure that those people who handle these kind of cases are competent and do a good job. Ms. Patrick knows most or all of them, I suspect.
I do.
And she can talk to you about them. You can't pick your attorney, but one can be appointed to you from the group that is known as the Public Defender's Office. And so that's up to you how you want to do that, okay? Okay, thank you.
Thank you, Your Honor.
That is all for the record.
You want something? That's the last one.
Also with me.
Yep, thank you.
See ya.
See you.
Sorry.
Yeah.